Kenneth Clair has spent more than 3 decades in prison for the rape and murder of a young woman in Orange County, California. But he's been seeking a retrial ever since Private Eye C.J. Ford uncovered the fact that the county DA had tested DNA evidence found on the scene and that it didn't match Clair.
The district attorney office really had it in their minds that we have the right person and we're going to prosecute him and we're going to put him on death row and we're going to see that he's executed.
Question about what they are not doing for Kenneth and why they are holding things that could help him.
The Orange County DA withheld the DNA results from the defense at the time of Clair's earlier appeals. But this isn't the only piece of information the county withheld in this case, and prosecutors withholding favorable information isn't a problem limited to the Clair case or to Orange County. When it comes to deciding what evidence a jury should hear when deciding innocence or guilt, the American criminal justice system entrusts prosecutors with extraordinary power.
The issues in the Clair case, certainly the one that's been getting the most attention is the DNA results and the fact that they haven't been turned over. But then in an overall sense, the question is, what else may be being held back?
Scott Sanders is an assistant public defender in Orange County. He's made a name for himself by exposing the fact that county prosecutors recruit jailhouse informants to solicit confessions from their fellow inmates in exchange for reduced sentences and then testify in court. And it's done all without revealing the nature of the payoff to the jury.
The key issue with incentives is playing by the rules. I mean, if you're going to give an incentive, be upfront about it, disclose it to the defense, and let jurors and judges know what's going on. That's the only way you're going to get a fair trial. If you play games with that, you risk very much the prospect of people being wrongfully incarcerated.
Jailhouse informants don't play a role in the Clair case, but Sanders believes that there are serious problems with at least 2 witnesses in the case. The first is Pauline Flores, Clair's ex-girlfriend who supposedly caught Clair confessing on tape.
You blew the motherfucking tape. Not next to your motherfucking mouth.
That's not a confession. That's just like, hey, just like leave me alone type of thing.
Regardless of the credibility issues with this alleged confession, one big problem is that the prosecutor and the witness denied to the jury that she received anything in return for her cooperation. It was only decades later that she admitted that the police took care of an outstanding warrant for wearing a wire and extracting something that sounded like a confession.
The reason why it's important to disclose information regarding a witness in any context is jurors are making an assessment about credibility. So if a witness comes in and says, I'm here out of the goodness of my heart, or I'm here just because I'm interested in helping the justice system, when in fact there's a benefit, one of the issues is, and an important issue is, should that jury find the witness credible or not? That credibility determination, especially for a witness like Pauline Flores, is critical.
Another witness was Margaret Hessling, the owner of the house where the murder occurred, who testified that Clair stole a turquoise charm belonging to the victim on the night of the crime. Sanders discovered that Hessling was in the middle of a big welfare fraud case at the time of Clair's trial. Prosecutors in that case downgraded her crime from a felony to a misdemeanor and a $500 fine after she provided special info on another case only 13 days after Clair was convicted and sentenced to death.
Jury in the capital case never sees it. She gets this enormous benefit. It's bad enough because it's kind of obvious on its face, but we've seen this pattern in multiple cases where as soon as the jury comes to their verdict in the case that the prosecution's handling, they go out and give a pretty extraordinary resolution in the witness's case.
The prosecutor in the case was a man named Michael Jacobs. He ran Orange County's homicide unit for years and obtained convictions in several death penalty cases.
Michael Jacobs, to me, and I'm just going to tell you personally, a very evil prosecutor. He wants recognition. He likes the idea of winning at all costs.
We're looking at a prosecutor who, on a number of cases, did not have discovery turned over on a number of capital cases. The worry here is what else is out there that hasn't been turned over.
Michael Jacobs won a conviction against a man named William Charles Payton in 1980 for a rape and murder after a jailhouse informant helped secure a death penalty conviction for the prosecution in exchange for early release. The jury never knew about the deal, and the informant went on to commit a murder on the outside. California executed Thomas Thompson in 1998 for a rape and murder. Once again, the testimony of jailhouse informants sealed his fate. And once again, the jury and the defense never heard about the deals they cut with the county. The prosecutor in the case was Michael Jacobs.
We know he's handled a lot of homicides. He was in the homicide unit for a number of years. He was the head of the homicide unit. Do we just assume that somehow in his other cases he turned over favorable evidence? We should just go on and those people in custody should die the death that no one wants, which is a death in a prison after you're spending many years there. Should they just die without having a re-examination of the case? I don't think so. I think every one of his cases should be re-examined.
Jacobs declined multiple requests to participate in this documentary. But Sanders discovered old correspondence between Jacobs and the State Attorney General's office handling a number of appeals in his death penalty cases. In one letter, Jacobs complains that the office finds it necessary to show everything we have to the defense, saying, "This is a new concept for me." The DA later fired Jacobs, but in its termination letter didn't cite anything about his attitude towards withholding evidence and seemed most upset about his insulting and demeaning tone when interacting with the State Attorney General's office.
What they were learning in those letters should have been enough to open an investigation about every one of Michael Jacobs' cases. Once you pass this line where we lose faith in whether you're turning over evidence and you're always turning it over and you're making that assessment and you're worrying deeply about defendants' rights, a case like Clair where there's already problems, boy, we should all be worried.
But just how widespread is the problem of withholding evidence in the criminal justice system?
This problem is not limited to Orange County or any one jurisdiction. This is a problem that we've seen across the whole country. You can see it from our data. We found that there was an inordinate number of cases involving exactly this problem.
Kathleen Cookie Rodolphe is a law professor at Santa Clara University and co-author of a study on evidence disclosure.
When you look at the problems with what prosecutors do, we're always looking at the prosecutors themselves. What we decided to do was not look at the prosecutors, but look at the courts, look at judges, look at judicial rulings to see to the extent to which what the courts are doing in some way is either encouraging non-disclosure or encouraging disclosure.
Rodolphe and her colleagues examined about 5,000 cases and found 620 where prosecutors withheld favorable evidence. Judges ruled that the withheld evidence only constituted a violation of law in 22 of those cases.
Courts are just okay with prosecutors withholding favorable evidence. And that's really troubling because we know from post-conviction analysis of DNA cases that the withholding of favorable evidence is a key cause of wrongful conviction.
Another trend the researchers uncovered was that prosecutors were most likely to withhold evidence in death penalty cases.
The truth is, actually, that finding is consistent with what I've been finding in all of our studies, which is that you tend to see more problems in the more serious cases. And I can speculate and say that the fact that prosecutors have so much at stake in a serious case, particularly when it's a death penalty case, to win the case, their motivation may be a little greater to cross the line.
And it's not only that the cheating gets worse as the stakes get higher, but it appears that the prosecutors who cheat once tend to do it again and again. Rodolphe found in California that a third of prosecutorial misconduct cases were against prosecutors whom courts had found guilty of misconduct before without facing discipline.
There are many prosecutors out there who are doing the right thing. What I say to them is it's important that we stand together because those prosecutors who are deviant are actually, they're cutting into the integrity of the whole system. When your primary objective is to win convictions, it explains all the problems that we're talking about. Because a prosecutor's job is to act in the interest of justice and come up with and reach the right result, not to win convictions. If you want to win convictions, you take shortcuts, you hide evidence, you don't disclose deals.
You've got to put winning way secondary to everything else. If you do that, if you say, look, what we want you to do, number one, is disclose what you're supposed to, and we'll live with bad outcomes. We'll live with acquittals when they come, then the system's going to work a lot more fairly. One of the reasons for real concern on a case like Clair is we now identified some issues for concern, and they're pretty substantial. But the real concern, probably more so, is what else wasn't turned over. And what do you do in those cases? With the failure to disclose that in a case like Clair, the right outcome, at the very minimum, is to give him a new trial.
I couldn't believe that the DA was sitting on all this evidence now and not testing it. So I found out that they were testing it, and they knew that the DNA didn't match Clair's. They didn't find any Claire's fingerprints. They found someone else's fingerprints, but there's nothing on the crime scene that belongs to Claire.